Now, what are the main problems in liberalism? We've just encountered one, and we've seen that there can be a liberal response to it. But liberalism shows, even by responding, despite problems, shows that it offers a very great deal. It requires that we don't impose moral, social, or political systems or ideologies or schemata on people. It requires that we accept and tolerate individuals' rights to choose their ways of life freely. It requires that we protect the rights and freedoms that people have so that they can make their own decisions and choices. But can liberalism fulfill these promises? It can some of the time. What are the problems? Some of them are conceptual. First of all, abandoning any substantive ideology. Liberalism, understandably, claims that we must not, requires that we do not impose any substantive ideology on anyone, and that we accept a very wide range of ideologies and approaches to life. That's understandable in view of the horrors which any number of imposed ideologies and religions and other moral and political systems have caused. We're very familiar with those. But the problem is that the liberal position itself amounts to a substantive ideological commitment. In effect, it's an ideological commitment not to impose an ideology. And this causes problems. It implies, for example, not intervening when a system or an individual causes serious harm in the service of an ideology. Liberal theorists aren't always aware of the problems they face here. We've already mentioned John Stuart Mill's call for liberal values. He actually called for this to be imposed on India, right, by force. He thought Indian culture could not understand liberal values. John Stuart Mill, the great 19th century liberal, said that liberalism would have to be imposed on India by force. We've also noted the contradictions in liberal interventionism. The claims say to bring freedom to other nations by invading them and, in effect, occupying them and taking them over. We noted that in the last 2 or 3 lectures. But what then about specific rights in liberalism? The right to choose. This is, as we've seen, the individual is a basic unit of society and is therefore the holder of the right to make free choices and decisions, whether in occupation, way of life, moral and political attitudes, sexual preferences and orientation, and so on. The idea is highly attractive, particularly in response to the kinds of, and in contrast to the kinds of coercion which entire systems often impose on people. And therefore this idea of an individual right to choose has had an enormous impact on entire societies around the world. It's also given rise to very extensive protections in law and in institutional systems. The example I gave you of the youngsters who came to see me to ask me to open up a room in that college so that they could conduct their namaz at lunchtime on Friday, it's a good example. They were perfectly entitled to do so. And English law specifically allows for that. Yeah? Incidentally, we had no dress code in that college, and the students could come in just about anything they liked. In hotter weather, we, the staff, often came in shorts and casuals, because good weather in that part of the world is something you try and make the most of when you can. Not all the faculty liked it, not all the staff liked it, but many of us did. Okay. Extensive protections have resulted from the recognition of individual entitlements to various rights under liberalism. But what happens when we see the individual as a chooser and nothing else? How then do we evaluate the choices and decisions individuals make? Because if we start evaluating people's choices and decisions, then we're at risk of infringing their right to choose. If we start saying, well, that was a good choice and that was a bad choice, or that's going to have rotten consequences or whatever, we're, at least in principle, opening up the possibility, or creating the possibility, that we're going to restrict their choices or infringe their right to choose. And yet, if we accept the right to choose as inviolable, as absolute, then we're also unable to see what is and is not a free choice. We're unable to evaluate whether someone, themselves or ourselves, is manipulated or coerced or brainwashed or deceived, or whether our decisions are a result of prejudice, misinformation, ignorance. You know, we could even choose to stuff ourselves with junk food or consume other harmful substances or anything else. And these are significant issues in liberal systems of law. But conceptually, if we were to raise any questions about such conduct, we would have to investigate the substance of the actions, the context, the backgrounds and reasons, the wider social and political systems and contexts, and so on. The result is that if we take the right to choose as an absolute, then liberalism leaves us without any of these other resources. All we're able to protect is the right to choose. And that then means good, bad choices, harmful choices, the context of choices, the background disappears. Now, I take that from Ronald Biener's excellent book on liberalism, published about 25 years ago. Well, what then about the concept of rights? Rights are fundamental to liberalism, but how then is liberalism to protect the individual, this bearer of rights? Constitutions, and they're very significant. We're very familiar with major cases in which rights have been asserted or denied or altered and so on. But for liberalism, rights are a fundamental concept, and yet it's riddled with problems. Consider, for example, the right to freedom of expression. This has even resulted in a Supreme Court decision which indirectly confirmed that students at George Mason University had the right to hold an ugly woman contest on campus. The background is this: students did hold this contest. It was men, unsurprisingly. There was public outcry over it. I understand that they made a formal apology. The case is detailed in the United States education literature. It's on the net. But if I'm not mistaken, the university then sought to impose formal disciplinary proceedings. Again, if I'm not mistaken, if I remember the case correctly, the students considered that this was punishing them a second time for the one offense. They took the case to court and won in, if I'm not mistaken, a United States Federal Circuit Court ruling, which said that this was double jeopardy. They were being tried and potentially punished twice for the same offense, and that this was unacceptable. One implication is that the ugly woman contest is therefore permissible under the United States Constitution, under the First Amendment. Well, the fact is that this kind of contest, this ugly woman contest, may stand as a right, but it exposes the organizers' misogyny and hatred of women. That's the only thing it does expose. But under liberal principles, the only thing that counts is the right. Right? That's one implication of the ruling. Similarly, right, what about a right that isn't worth having? For example, in certain states of India, there's a practice of appointing unqualified teachers on very low salaries in place of qualified teachers. If I'm not mistaken, this practice was initiated by certain states after the passing of the otherwise thoroughly laudable Right to Education Act. That was passed in 2009 and gives legal expression to the constitutional right to an education. But certain states very soon after that started appointing unqualified teachers instead of qualified teachers. They paid them far less. In fact, there's research which quotes some of these teachers as saying they were so badly paid that they could not even bribe their way to better jobs or to better paying jobs. Now, what was going on here? If we look at the context of this particular employment practice, we find that one of the aims of the Act was to increase enrollment in schools. Absolutely laudable. And the states concerned did increase enrollment in schools very greatly. They said, in effect, you told us to get kids into schools, we did so. We're now employing unqualified teachers. But was that then a way of getting round an implicit requirement of the Act? The unqualified teachers were just that, unqualified, and presumably were simply not experienced and qualified in the ways to teach the specified syllabus to the pupils. So the states were meeting the formal requirements of enrollment, of increased enrollment, but were they then getting round the intended substance of the act? So were the students, the pupils, then getting a right observed, yes, a right to access to school, a right of access to school, but not a right to an education? Is this a right that is worth having anymore? We've got the right of access, but not a right to an education. That's not being discharged in respect of us. Yeah? So there's no point having a right to something which it simply isn't worth our while to have. But that means examining the content of the right itself and how it is delivered. Well, there are even more problems with the idea of rights. We're familiar with this. The right to freedom of expression often clashes with the right to freedom from expressions of prejudice and bigotry. But if rights are absolutes, then clashes of rights can't be resolved within liberalism. Well, the examples are endless. There are any number of them. The right to a traditional way of life is often claimed. But the traditional traditions in question might and often do require, say, the subjection of women, or they may compel compliance in other ways which violate liberal principles. This has all been thoroughly documented. The difficulty here is that liberalism offers us none of its own resources with which to address clashes of absolute rights. Some attempts have been made to evaluate rights claims against one another with another formula, for example, under calculations of relative harm or costs and benefits. But this leaves unaddressed the question of how particular things came to be seen as rights in the first place. And this approach also accepts if we can trade off rights in a calculus of some kind, then rights are not absolute. Well, what happens if we then, there's a neoliberal approach which says, well, leave it to the market to decide. But that abolishes the idea of rights. Let the market decide means nothing is a right. Yeah? It ignores the fact as well that the market itself depends, as Adam Smith knows very well, on non-market values such as contracts and the enforceability of contracts. If a contract is a moral value, is it contained in the market transaction itself? Adam Smith is very clear about that. It isn't. Right? But one non-market value, as he says, is the idea that a contract is morally binding. Where does the morally binding nature come from? Legally enforceable? Is that in the market transaction itself? It isn't. Another consequence is that market exchanges themselves depend on trust and confidence. If we don't trust somebody, or if they betray our trust, then the very idea of the market or the practice of the market collapses. Now, there are other ways of trying to preserve the idea of rights against challenges, and one way is something we've already encountered. That's the noted liberal way of giving a special status to procedural rights, such as the right to a fair trial or free and fair elections. Now, these have been regarded by some liberal theorists as absolutes, in contrast to what they sometimes call material rights, rights to employment, rights to public housing, and so on. These are all ruled out by certain sections of liberal opinion on the grounds that they require money and will therefore be the subject of endless dispute over how much somebody is entitled to, and so on, how much is to be spent on them, such things as that. Those have been called material rights or economic rights. The distinction between procedural and material rights can look very attractive. But the problem is this: fair trials and free and fair elections and so on themselves require public institutions and a great deal of public expenditure. How much does it cost in public funds to run a general election in India? And would we want to say that less should be spent on those by the state? This is ensuring the electoral registers are accurate, having the civil service officials ready in every state and every region to conduct the election, to count the results, to make sure the codes of conduct are applied. Then the model code of conduct is, if I'm not mistaken, not enforceable, but the candidates do take it very seriously and have to do so, right? Now all that costs a very great deal of money, and we would say rightly so. We have to do this right if the election is to be trustworthy, if it's to be fairly conducted, and if it's to be procedurally sound. So is there any difference in kind between procedural rights and material rights? We still have to spend public money on them, we still have to justify them, we still have to have institutions to protect them, ensure that they're carried out correctly, and so on and so forth. And therefore, what looks like an issue in kind turns out to be, among other things, an issue of differences in degree. Why is it that we're prepared to spend hundreds of millions, perhaps billions, on running a free and fair election? You know, European Parliament elections, an electorate of, well, the population is about 528 million or something like that. The electorate is likely to be about 2/3 of that, I'm guessing here. But running a European Parliament election costs money around the whole European Union, right? And think of the United States. Yes, we know the candidates spend a very great deal of money, but they're allowed to under US law. But running the election itself, with a population of 330 million or so and an electorate of about 220 million, itself requires public funding. So it could well be, as my former colleague Raymond Plant and some of his colleagues have argued, that there is no difference in kind between procedural and material rights. If rights are to be taken seriously, we're going to have to spend public money on them, and we will need public institutions to protect them and ensure that they're observed and so on. So there's a further question here on top of that. Are we in any position to choose? If we're seriously sick or starving, we're in no position to start choosing in the way liberalism seems to think we should be. Most contemporary liberals seem to have accepted this point. If we're seriously sick or starving, we're not choosing beings in the way liberalism imagines us to be. Even a very extreme proponent of liberalism, like Friedrich von Hayek, who's often been called a libertarian, advocates a social safety net. The implication is that as the economy expands, and of course an economy run on Hayekian lines according to Hayek would only get better and better, so the implication here is that as an economy expands, the social safety net will also expand, right? But Hayek regards the expansion or contraction of an economy as a natural law, because we can't actually know the outcome of our actions in the overall market. But that is a philosophical claim about the nature of knowledge. It's an epistemological claim. And Hayek is well aware of its dangers. He himself says we must not tell people that the outcomes of the market are very much a matter of luck. And he says we shouldn't say that because they will lose the incentive to work. This is well recognized. I mean, the quotation is not that hard to find. But neoliberalism in particular, Hayek is a particularly extreme example, has been something of a fundamentalist religious crusade. It's been very similar to those. And that means that there is still no widespread admission of its comprehensive failures. But it also means that major aspects of the global trading system are invisible to neoliberalism or neoliberal theorists. Things like the weaponization of trade. That's actually a term used by the people who've written about this, Harding and Harding. The application of sanctions and so on also counts. Import duties and tariffs, selectively devised and imposed, is a form of weaponry. Well, what does this mean for liberalism as a whole? In all its forms, it promises a lot. In practice, it has been, at least in part, responsible for the global recognition that in democracies, political power needs to be justified, legitimized, and controlled by public processes and institutions. Liberalism has, however, probably never been implemented fully in any of its forms. Neoliberalism has been severely criticized since its revival in the early 1980s. It's had even more criticism since the 2007-9 global financial crash, and even international financial institutions have admitted that many of the precepts of neoliberalism don't work. Right? For example, the International Monetary Fund has acknowledged that the policies it imposed on Greece in 2015 both would not and could not work. Even the IMF admitted it, That's in a book written by the former Greek finance minister Yanis Varoufakis. But on top of that, detailed arguments have been put that neoliberalism in particular doesn't replace the state with the market. It amounts to a takeover by commercial financial bodies and very large manufacturing corporations. This again has to do with the idea that the only way to resolve any issue is to leave it to the market. The upshot is that major bodies in markets have effectively been able to shape markets as they wish. The examples are legion. In 2013, the Vodafone Corporation held that it wasn't liable for UK tax because it sold its holding in the US corporation Verizon for £84 billion, 84 billion, and the relevant share was owned by a holding company based in the Netherlands and was therefore not liable for UK tax. Objectors maintain that Vodafone is based in the southern English town of Newbury and should therefore have paid tax on the deal. Right? This kind of issue keeps arising. Now, well, what about other problems with liberalism? Yes, they all share the promise of all manner of freedoms, but they also share the problems. And the main problems are, as we've seen, clashes of rights and what amounts to an unstated, often unacknowledged dependence on a very substantial theory of human nature. This is the idea that humans are choosing beings above all else. In effect, liberalism delivers us into its own forms of captivity. That is, forms created by the very terms on which liberalism is founded. Many of the conceptions of rationality have been involved in liberalism. For example, the idea that we're rational choosers have been very severely criticized for even gross assumptions about what it is to be rational at all. One utility theorist has even said that our brains are an obstacle to rationality. I think the argument there was that we are habituated to act in certain ways, and according to this particular applied psychologist, I think that's what he is, or possibly neuropsychologist, according to this particular piece of research, our brains then develop, if I'm not mistaken, neural pathways which may then result in our not doing the rational thing as defined by, in effect, an economic rational theory of action. So our brains themselves become an obstacle to rationality. But that requires that we question the idea of rationality that is at work here. It's not clear that liberalism can actually accommodate questioning what it is to be rational. The idea is that we're all rational choosers, according to liberalism, and therefore that our choices are, in a sense, absolutes. Well, yes, it may be slightly flippant of me to suggest that the consequence of this particular piece of work on rationality, this particular piece of research, one implication is that we should then remove everybody's brains. Because if our brains are an obstacle to rationality, surely the rational conclusion is that our brains should be removed. I'm being, well, partly flippant there, but even the Nazis, as far as we know, did not think of that. As for liberalism, well, it is at its best a genuine ideology, a way of thinking, but it unintentionally but systematically misleads us. At worst, as in the case of Hayek, it can only be sustained by a gigantic lie. Yes, it involves significant misconceptions, or it leads us into significant and irresolvable problems on its own terms. It has promised an enormous amount. It has had an undoubted impact. It's had enormous successes, particularly when rights under liberalism have been claimed in response to systematic oppression. But rights themselves create further problems, and the failures on the part of liberalism to deliver are not only empirical but also conceptual. So that concludes our topic on liberalism, how liberal ideas occur in contemporary democratic states and often highly significant, and on how these ideas pose significant, equally significant questions for other kinds of ideas about society and human conduct. We're going to look at an example of a case in the Supreme Court of India. That is the case of Shafin Jahan versus Ashokan and others, in which the Supreme Court issued a ruling in March 2018, having considered the case for, if I'm not mistaken, about a year, certainly for several months. We'll then look at two analyses of the judgment, both of which recognize good things achieved by the judgment, but are also severely critical. And we'll try and reach some kind of conclusion about the whole episode. So these are the sources which we shall use. Certainly the Supreme Court judgment itself, and that is freely accessible in PDF form on the net. There's an article by Apurva Vishwanath in The Print, which I think is an online journal and is freely accessible on the net. And there's an analysis by Suhrit Parsarthi of the judgment, of the case and the judgment in The Hindu. Suhrit Parsarthi is a lawyer, practices in the High Court of Madras, and has written this among his other articles for The Hindu. And that too is available with, I understand, limited free access, but it is accessible. So you'll have this list as part of your materials for this particular concluding part of the liberalism topic. Well, we're going to start by looking at the facts of this case. The case is Shafin Jahan versus Ashokan and others, and it's often more popularly known, more widely known as the Hadia case, because of the name of one of the people involved, perhaps even the central figure in the case. So we'll start with an account of events. The main facts are reasonably well known. A woman aged 24 was studying for a homeopathy degree. She converted to Islam and in the process changed her name from Akhila to Hadia. She also moved into a hostel run by an Islamic organization. In January of 2017, Hadia's father, Ashokan, claimed in the High Court of Kerala that his daughter, Hadia, was being illegally detained in the hostel. The court rejected that claim. That was in January 2017. In August of 2017, Ashokan alleged in the Kerala High Court that Hadia was at risk of being taken out of India. In December 2017, with that second case still in progress, Hadia married Shafin Jahan. This was a man she had met during her time at the homeopathy college. The court annulled Hadia's marriage. It said she was, I quote, weak and vulnerable, capable of being exploited in many ways, end of quotation. The Kerala High Court also put Hadia under her father's custody. Now, Shafin Jahan, the husband, appealed the decision to the Supreme Court of India, and the Supreme Court took the case, if I'm not mistaken, sometime in 2017, and it considered two questions. The first was Hadia's capacity or incapacity to make a decision, and the second was whether or not she had been coerced into the marriage with Shafin Jahan. So those were the two main questions that seem to have been the focus of the Supreme Court's concern. We'll look at them turn by turn. The first question was that of incapacity to make a decision. Was Hadia incapable of making a decision on changing her faith, and by implication also on getting married? Now, analysing this question involved the Supreme Court in close examination of the existing Indian case law. As it happens, much of the case law in this kind of matter is inherited from decisions in the British House of Lords over a fairly long period of time. The Supreme Court bench found no reason to doubt Hardia's capacity to make a decision. The second question is that of whether or not Hardia was coerced into her marriage. The Supreme Court heard Hardia's own testimony, and in so doing, in hearing her, the court upheld the principle of habeas corpus, and the bench concluded that Hardia had made her decision to marry Shafin Jahan entirely, freely, and of her own will. So she was in no way incapacitated in making a decision, and she made the decision to marry Shafin Jahan entirely of her own free will. So the Supreme Court quashed the Kerala High Court's decision, and it noted many errors in the lower court's reasoning. The Supreme Court decision is about 60 pages long and very clearly written. It is very accessible. Now, some key results of the decision have to do with the Constitution of the Republic of India. One of these is that the right to marry a person of one's own choice is a fundamental right under Article 21 of the Indian Constitution. A second result is that matters of belief and faith, including whether to believe, are at the core of constitutional liberty. That's a quotation from the judgment. I'll repeat it. Matters of belief and faith, including whether to believe, are at the core of constitutional liberty. A third result, another quotation, the Constitution exists for believers as well as for agnostics. Those are things that the Supreme Court itself said. Now, those rights and principles are grounded in liberal political thought, in particular, as Article 21 says, the rights of the individual. Now, the Supreme Court ruling clearly upholds and further specifies the scope of Article 21 of the Indian Constitution. So it upholds Article 21 and further specifies the scope of that article, Article 21 of the Constitution. But the court was sharply criticized, despite being widely praised for ultimately upholding Article 21 and for showing us more specifically in what kinds of contexts Article 21 is to be upheld and is to be observed and followed. But the court was nevertheless sharply criticized. For what? Certainly for omissions from the judgment and for what seemed to be unnecessary procedural delay. Well, we need to look at these criticisms in more detail. The first one, the first set of criticisms, is here. In an article by Apurva Vishwanath, written in 2018, published in an online journal called The Print on the 13th of April 2018, and the title is "Before You Cheer Hardia Judgment, Spare a Thought for What It Did Not Say." You'll get the link to the judgment anyway as part of the materials for this lecture. Well, what did the judgment not comment on? It made no mention of what Hardia endured during her 10 months of near captivity in her parents' home. During that time, she was not allowed to use a cell phone. She was allowed no access to the internet, and apparently was allowed no visitors except in the presence of her parents. Vishwanath then makes another point. Hardia repeatedly said during her testimony in the Supreme Court, "I want my freedom." She also said, "I want my husband's companionship." The Kerala High Court had used Hindu personal law, which says an unmarried woman is the responsibility of her parents, to order her to her parents' home. That is, the Kerala High Court mentioned Hindu personal law in making an order that Hadia should live in her parents' home. Now, Hadia herself said, "Shafin Jahan must be my guardian." I quote, if Hadia was to have a guardian at all, and remember the Kerala High Court had earlier ordered that that was to be the dean of her college, so if Hadia was to have a guardian at all, she wanted it to be her husband. Now, in the Supreme Court, the National Investigation Agency, the NIA, insisted that Hadia should not be allowed to speak until it, the NIA, had collected evidence that she was, I quote, "brainwashed by," again I quote, "a well-oiled organization working in Kerala which supported terrorist causes," end of quotation. Now, Vishwanath's conclusion to the article is this, that the Supreme Court judgment utterly fails, I quote, "utterly fails to capture the hurdles, both institutional and personal," end of quotation, which Hadia faced throughout the two court processes. We should say 3 court processes, because her father went to the Kerala High Court twice. So let's go back over that again. Vishwanath concludes that the Supreme Court judgment utterly fails to capture the hurdles, both institutional and personal, which Hadia faced throughout the court processes. So that's one criticism of the Supreme Court judgment. Yes, the Supreme Court upheld and specified further the application of Article 21 of the Constitution. But what it left out of the judgment were the obstacles that Hadia faced throughout the Kerala High Court processes that she underwent. Well, there was another criticism. Yes, Vishwanath has sharply criticized the Supreme Court for leaving out the personal and experiential issues that Hadia faced, the experiential issues of effectively being, how do we put it, held captive, is that the right phrase, in her parents' home, and not just the refusal of her freedom, but the refusal of the High Court and her parents to accept her own wish that if she was to have a guardian at all, it should be her husband, Shafin Jahan. The second main criticism is of the delays in the Supreme Court process. This is an article by Suhrit Parsati, written in 2018, published in 2018. It's called "The Hadia Caution." It was published in the Hindu on the 20th of April 2018. And Suhrit Parsati also commends the Supreme Court's ruling. Almost every observer has held that this is the right decision to have made, that is, to have upheld Article 21 of the Indian Constitution. But Parsati points out that the court did not see Hadia until November 2017, that is, until 6 months after it had started hearing the case. This almost amounted to a violation of the principle of habeas corpus. That is the requirement that a detainee must be present in court so that the court can decide if their detention was lawful or not. By the way, that requirement, the principle of habeas corpus, as Parsati points out, is very ancient indeed in English common law. It predates the Magna Carta of 1215. It dates from some time earlier in the 12th century, if I'm not mistaken. And it is the requirement that if someone who is detained, well, if someone is detained, they must be put forward, presented in court, so that the court can decide if their detention was lawful or not. Secondly, Patsati points out that the Kerala High Court had annulled Hadia's marriage to Shafin Jahan, and it had done so while in fact hearing a writ of habeas corpus. So the clear implication is that the Kerala High Court had carried out one action, one legal action, that is annulling the marriage, while hearing a writ about quite another legal matter, which was the question of habeas corpus. But Patsati brings out both those points very well, and the point for us to remember is that the judgment undoubtedly upholds the Article 21 of the Indian Constitution, but what it leaves out is a great many of the wider social and cultural aspects of Hadia's situation, of the pressures that were brought to bear upon her, not only by her parents and perhaps other relatives, but also as a result of the orders of the Kerala High Court, which she obeyed, even though she was clearly extremely deeply troubled by them. Now, that shows us how a liberal principle, that is the rights of the individual as expressed in Article 21 of the Indian Constitution, how the rights of the individual, a liberal principle, can and frequently does conflict with long established cultural and religious conventions and practices and institutions. We saw earlier that liberalism, when proposed in its own time in the second half of the 18th century and through into the middle of the 19th century, by which time it was well established as a dominant political doctrine in the global north, we've seen how liberalism, when it was proposed in its time, was not only a challenge but revolutionary. Liberal principles are now, as we have seen throughout this topic liberalism, liberal principles are embodied in a very great many liberal democratic constitutions. And this case, Shafin Jahan versus Asokan and others, is an example of just how far-reaching and challenging and potentially revolutionary liberal principles are in virtually any society. These kinds of issues arise all over the world when liberal principles are tested in the courts over substantive social, cultural and political issues. So that's why we've covered this case. It is very well covered in the Indian press, it's been covered in great detail. Many of the commentaries and analyses are really excellent, and the three sources I've used here are accessible and very clear. The judgment itself is very illuminating. So we now conclude our topic, liberalism, and we're ready to move on. Our fourth topic is Marx, and we shall meet that next time.